saying there's a vibration. I think most of you are, clearly can hear me. Okay. Chale, theek hai. Okay, so today we are going to start with, this, it used to be uploaded on YouTube, right? So, but I suggested de facto IS that, it is better to do it live, like we used to do that, syllabus explaining. Okay. So the same thing that will happen here itself. Okay. What I will do that there are, 8 questions, right? And each question have 3-4 parts. Like question number 1 and 5 have 5 parts. Okay. So it means each day I will discuss, 3 to 4 questions, not each day, on Monday, on Thursday. Okay. So 2 days in a week. So I mean, 2 questions for law optional, 8-9 question I will discuss a week, right? So it will take around 1 month to discuss the whole solution of that paper. Okay. So it means the next 3 to 4 months, right, till mains, I can discuss at least 3 to 4 paper. Okay. So that will be good for you. And those who are appearing this time, right, might be preparing for prelims itself, right? So for them also this is better, right? So they can at least give 2 days in a week, and hardly I will take, half hour, maximum 45 minutes plus. Okay. So that is, best in a way that you have to only spend 45 minutes and you will understand. Okay. At least once you will revise the specific topic. Okay. Now, this PDF that is there, that will be available on the Facto Law website. Okay. So you can go and see that there. Okay. So that is not an issue. Chalo, so let me share the screen. Okay. And let us understand. Now, this is the screen. Give me a minute. I'm sharing the screen. Okay. Yes. So all of you can see the screen nicely, right? Now, if you look at this screen, right, one thing that is absolutely clear is that we have sort of, paper 1, right? I have already discussed paper 1 in detail, right? So it had 5 questions, 1 to 5, sorry, 1 to 4, right? 1, 2, 3, 4 questions, sorry. So that I have already discussed, right? Now in paper 1, part B, that is international law, right? So question number 5, which contains 5 subpart A, B, C, D, E, right? So this is the 5 question that I will discuss today. Okay. Now again, the structure will be same. I'll be talking about the main concept that involves the demand of the question, right? And then I will go on, and tell you that how you can write it down, right? Now, one more thing I must add here, that what you can do, that any of you, right, may send me, one question out of these 5, any one question. Now remember that I will not check each and every paper. That is obviously impossible for me to check. But what I can do actually, that I can take one copy at least, right? And I will take different copy each day if not of people send me. Okay. And I will check it here, here itself, right? So that, like this copy that I have, from previous batches, right? So like this copy that I have, right? From other batch, right? So that is how I will check, and I will, give you a feedback also, right? So that can be done, right? So if you want, I can help you with that. Okay. So you can, write any one of the question and send it to me. Okay. So that can be done. That will be very helpful to you. Okay. So let us start with the today's question. Now, today's question actually is the question number 5A, international law, right? What are the various steps involved in the concluding of an international treaty and bringing it into force, right? So various steps and bringing it in force, right? Now, bringing it in force basically differs from state by state, right? So every country have a municipal process through which the country makes that treaty in force. Okay. Now, most of the steps are very, sort of not very clearly identifiable, right? It is not a mathematical definition that you have these 5 or 6 steps, right? But overall, right, if you look at the treaty, right, then it is the Vienna Convention which, talks about the treaty law, right? So we'll talk about Vienna Convention in general, that how it codifies, all the customary law related to treaty as well as the new law that have been formed with it, right? Now, the steps, if you will see, right, so there are basically these steps, right? Those are basically adoption of text, authentication of text. Now, both are very different, okay? Authentication of steps actually, text actually includes, right, that the signature and the representative may be sufficient to deem to text to be definitive, right? Because what text actually is written. Okay, so once you affix your signature, that seems to be meaning of the authentication of text. Right? So it means that is why you must have seen normally in legal process also, each page is signed. Okay, here each paragraph is actually signed. Okay, so that is the authentication of text, right? Now, expression of consent, right? So the mode of consent that I told you differ from municipal legislation. I mean, differs according to municipal legislation. Like in India, basically it is the president, right, who give assent, or there are some treaty which may require parliamentary approval also. Okay, so that is what's written here also. Way of signature, right? instrument of treaty may be required. Okay. Similarly, consent, with various type of consent that we talk about, there's a consent by signature. One more consent that happens, a lot actually. You must have seen international treaty, right? People exchange each other folders, right? So that also amount to consent. Okay. So that is what consent by the exchange of the instruments. Okay. That India also follow. Right. Similarly, if there is a consent with regard to treaty where the constitutional law of that particular country require the parliamentary approval, that may be needed. Right. Like for an example, especially in US, if you want the international treaty to have a municipal effect in US, right, then it must require the consent of the US Senate. Okay. Then one more step that is not exactly the step, but it is one of the method of where the treaty, when you sign, right, so you can come up with reservation. Now reservation itself have been asked multiple times as a separate question itself, right? What do you mean by reservation, or what is the effect of reservation? Okay. Now reservation, you must have seen, it is a unilateral statement, right, where the state may reserve that, okay, I'm signing treaty subject to these conditions. Okay. So it is a very simple question, right? These 3-4 steps. Okay. So that will be sufficient. The conclusion here, as per per se, is not needed at all, right? You have to simply talk about little bit that Vienna Convention of Law of Treaty, how it codifies everything, and then you write the steps, right? Give very clear heading to each step. Okay. So that will be much better. Now, as I told you in the beginning, there can be other steps also, right? Discussion part can be also there. Amendment part can also be there, right? So there are multiple small steps, right? But the major steps are these four. Okay. So that is what, is required. Right. Now, let us come to question number 5B. That is a very interesting question, right? What does it say? It says that WTO member X agrees with a non-member country Y, right, to reduce the tariff on the product A to 7%. Can the WTO member claim the same level of traffic on like product A from this? How the dispute settlement bodies define the like product in Article 1 of the GATT, right? General Agreement on Trade and Tariff. Now, the main question is here with regard to like product, and one doctrine, that is your doctrine of non-discrimination. Okay, the doctrine of MFN rule, right? That is one of the non-discriminatory doctrines. What you have to do, that you have to first introduce WTO and write that how it is the one of the evolving, or you can say one of the evolved organ of the GATT itself, right? See, when this Bretton Woods conference took place 1945, so 3 institutions were supposed to be created, right? First institution that was supposed to be created was with regard to, if you must have seen, right, with regard to World IBRD, right, that is the bank. Second institution that was supposed to be created was basically, WTO, also referred there, International Trade Organization, right? And for that we had a document which was, accepted normally, right? That became actually GATT. Okay, understood that particular point, right? So this and the third was basically referred as IMF, right? So all of them was a Bretton Woods institution, right? So you can write in the same manner here itself, right? It is one of the organ which was intended to be created in 1945 as a Bretton Woods institution, but could not be created, right? And a general agreement was there, and that ultimately became GATT. And then ultimately in 1995 became WTO, right? So a little bit of history about it, right? And then you will start with this concept of like product, right? You can start with, you can either describe this MFN rule earlier, or you can describe it later on, okay? But the main purpose of this is that like product, right? What is the meaning of like product? Now remember, what is MFN rule actually, right? Most favored nation. What does it say? It is a rule of anti-discrimination. What does it say? That suppose there is a country A, and it extends benefit to a country B, then he must extend the same benefit to each of the countries. Or indirectly, country A cannot discriminate on the basis of origin of the goods in a different country, right? So you cannot say that if the refrigerator is sold in India, if it comes from Pakistan, I will have X amount of tax. If it comes from Vietnam, I will have Y amount of tax. That you cannot do. Okay, so to simply say that you cannot discriminate against a product based on its origin. That is there in the constitution also. If you look at in the municipal sense, a state cannot discriminate with regard to taxation based on the origin on which that particular goods is generating, right? Like a state of UP cannot make a law that if a good is sold, manufactured outside the state of UP and sold in UP, I will be having a special tax. That they cannot do. Okay, the same thing applies here, right? So it is a principle of non-discrimination. Now, the non-discrimination applies only with respect to those products which are like products, right? Which are like product, right? Now the question is, how do you determine the things are alike? Now this is a question related to intellectual property law also, right? That when we talk about a trademark is given to a particular product in a category, right? So the another trademark cannot be given in a different category of same or like product, right? So what is the meaning of likeness, right? Now, if you look at the meaning of likeness, right? So there are two meaning of likeness actually. One is with physical characteristics, right? And second is likeness is functional likeness, right? Functional likeness means if it goes through the same trading platform or when the end user can buy it from the same store. Like for example, toothpaste and toothbrush might be a like product, right? Because they are sold at the same store, right? So the functional aspect actually we are talking about, right? So the both the definition have been included under the WTO itself, right? And the WTO have defined it in the similar manner, right? So I don't think that you will remember actually this whole definition of WTO. No one will actually, right? No one will, right? So you can write it very generically, okay? That what is the meaning of like, and this concept of likeness you can actually remember. Concept of likeness actually you can remember nicely. Understand that particular point? Okay, so quite simple at that, right? You can very easily understand and you can write it down. Okay, someone is asking me to speak slowly. See, I have a basic speed, right? So I don't think I'm speaking very fastly. Am I? No, I think not. Yeah, I'm speaking okay. Okay, this will be available publicly also, so no need. I right. If you want, you can sort of read it again. Okay. Okay. Done. Understood that particular point, right? So this concept of likeness you must remember, okay? Even though if you do not exactly remember, the concept or the definition of the like product in the GATT itself, right? It is somehow same definition as we have in our international property rights law, okay? I mean intellectual property rights law. Okay, now let us come to question number 3, the interesting question again. Okay, discuss the purpose principle governing the United Nations. Now this is the easiest question that you may have. Right? One is Article 2, Article 1, and Article 2 of the UN Charter. Second is what reform do you suggest for the UN system? Okay, what reform do you suggest, right? Now that reform suggestion, right? If you look at the number of reform that can be suggested is huge, but you have to sum it up. See, it is 100 mark. 150 words, right? So maximum allowable line is basically 15 to 20, not more than that. Okay, so in that sense, understand it. Okay, now if you look at question number 5C, then what you can talk about that you can come and write that okay, see, this is the UN Charter was enacted on this and this way, and this is the purpose and the principle, right? So Article 1 talks about purpose and Article 2 talks about principle. Okay, now if you look at these, right, it is very tough to memorize each one of them and write directly in exam, right? So the best thing would be so memorize at least 2-3 of them. Okay, right? So what is the important thing that you can think of, right? So you can here write sovereign equality, simple one line, sovereign equality. That is one of the principle on which United Nations is founded, right? Similarly, good faith and obligation by each nation. Okay. Third thing that you can think about is the peaceful settlement of dispute. Okay, now this peaceful settlement of dispute are something which is already in your syllabus, right? So if you simply remember the topic of your syllabus, you can answer this question. Okay, because whatever the topic of the syllabus, right, that is also the one of the principle of the United Nations also, right? And the second is and the last thing that you can write is basically with regard to using force, yeah, principle which prohibits use of force. Understood that particular point? So if you can remember even 4 of them, right, and little bit simply write the heading like sovereign equality, right? This principle identifies this. Okay, this dispute by peaceful settlement, yeah, peaceful or amicable means dash, write down. The United Nations Charter provides that the nation should strive to solve their dispute peacefully, right? So it means you simply write the heading and you simply reiterate the same thing in a different manner. Okay, 3-4 lines about it, right? So that will be more than sufficient. In fact, this question won't even allow you to write 3-4 lines, okay? Because you have to write separately the purpose and you have to write separately the principle, okay? So at least 4 line, both of them, right? And then you go on, turn yourself with regard to major function of United Nation or the reform that you can seek to achieve, right? Now with regard to that maintenance of peace, right? Here I have given article, right? So you need not to write the article. You have to simply identify that this is the function and here this improvement can be done, right? So with regard to promotion of peace and security, right, it involves many countries, right, but mostly it have failed to do so. A very important aspect of the international security, that is actually your preventive nuclear proliferation. Okay, so that is the remedy. I mean, that is the lacuna that you can point it out. It is not based on consensus, right? Not based on consensus, right? And it represents the world order which was there at the time of the World War, after the end of the World War II. Okay, so do not consider a multipolar world, right? Similarly, we can talk about developmental on management reform in terms of their processes, right? And the developmental reform in the terms of that, see, the aim of the United Nations should change from securing the world order in general sense to basically securing the world as a better place to live in. Okay, it means the development should be the more focused thing, right? Recently, all over the world, even India has started to make budget which actually talks about developmental budget, right? It means that what is the aim that a budget have and whether that aim have been fulfilled or not, right? So we have a separate publication where we talk about the sustainable development goals, right? And whether our budget have been capturing that needs or not, right? So that is the agenda that the UN should, and little bit they are doing also, right? Now the financial in financial aspect, right, you must be knowing more than 50% of the budget comes from one, right? So there has to be uniform policy with regard to the who pays it, right? Because the person who pays a particular organization will try to dominate that organization, right? That happens everywhere. CWHO, right? One of the example. Same thing happens here, right? So you can talk about this, right? And then you can talk about Security Council reform, the most important reform. Same thing, right? That it indicates the World War II global order, right? So it not takes into account the newer developments, okay? And then you can talk about the India's case for it, right? That why India should be included in that. Right now, there is sometimes a separate question, okay, discuss the case for India in its membership, getting a permanent membership of UN Security Council, but that is not here. So simply talk about simple reforms, right? So 3-4 reforms, subheadings, right? These are the major reforms that can be included. Procedural reform, developmental reform, right? The 3-4 major reforms, simply write down 3-4 lines about it. That's it, not more than that. See, word limit is 150. That has to be adhered to strictly, right? It might become 170, that's all right, but it should not become 200. Okay? It should not become 200, right? So you should not write excessive long answers, right? So that actually gives you negative mark, if you will. You must have seen by yourself also. Okay, now what are the parameter of contentious jurisdiction exercisable by the International Court of Justice, right? Now, how we'll have to approach it, right? So we first talk about ICJ and its relation with UN a very few lines, right? ICJ is independent, started as an independent body, but later on was appended to the UN Charter, right? Later on were appended to the UN Charter, right? And it was recognized, right? So that PCJ, right, Permanent Court of Justice, become ICJ. Now, then you talk about different type of jurisdiction in very detail. Okay, these are the jurisdiction, and then you talk about ICJ in detail. Contentious jurisdiction in very detail. What is the contentious jurisdiction? It simply means, right, now that whenever a party says that the ICJ do not have my jurisdiction, right, I do not have the jurisdiction of this particular case, right? So it means there is a contention of a party that I am not answerable to ICJ, or ICJ do not have a jurisdiction with regard to that case, right? Then ICJ decided whether I have it or not. That is actually referred as contentious jurisdiction. Right? If there is any contention with regard to the limits of jurisdiction, the ICJ is the competent to decide. Now, multiple times this question have also been asked indirectly. ICJ is competent to determine its own jurisdiction. Comment. Right? So the answer more or less will remain the same. Okay. Geetika is asking that his answer is required for. I'm not watching everyone what they are replying, right? So what I will do that once I am finished up with this, right, I will answer each one of your question. Okay. So let me finish up with this. Okay. Then it will be much better. And then you can talk about its importance or suggest reform if time permits. Otherwise, you can conclude it in this two major paragraph itself. Okay. Now here I've given some cases law also, right? Like in Nicaragua case, Cameroon versus Nigeria. Right now, remember, I have given here all of the cases, but you don't need to remember all of them. Even if you remember 1 and 2 of them, that will be more than sufficient, right? That will be more than sufficient. Okay. So remember that particular point. Okay. Then come to the 5E, very interesting question. There's a topic individual, right? So discuss the status of individual in international law, especially with respect to human rights treaties. Right. Now, individual, as you know, traditionally was not considered as one of the subject of international law, but later on it have been considered as one of the subject of the international law, because ultimately if you believe on the monoist theory of international municipal law, right, that clearly indicates that ultimately it is for the human being that both the law are being made, right? So the subject matter, and you cannot have a situation where you are saying that, see, I am making it for human being and human being is not the subject matter. Okay, so the things have actually started to change, and nowadays we are in a phase of the development of international law where human beings or the individual are considered as a subject. Okay. Now, you talk about international law in general that I talked about. Traditionally, individuals were not considered, right? And then you go on and writing with regard to these three provisions that how individual is the most important subject for these, right? Like in case of piracy, right? Privacy obviously occurs individually, right? A person comes, becomes a pirate, right? A whole company cannot be a pirate. Okay. Similarly, with regard to human right law, that is more important. That is actually has to be written in much better way, and this treaty law, right? See, ultimately, when we talk about either humanitarian law or human rights law, ultimately the question remains the same. I mean, the purpose remains the same, to protect the individual. Now, the method of protective individual might differ. One of them defines the right of individual and say that, okay, the state will not violate it. Other defines the limits that the state cannot cross, right? So ultimately, it is the human being which is subject to, right? Which is the central subject of both the law, right? You must have read also, there's a lot of time question, the difference between international human right law and humanitarian law. Okay. So you might say that both differs, right? But ultimately the subject matter remains same, right? Especially vis-a-vis humanitarian treaties, right? So yeah, I've given also. And when we talk about humanitarian treaty, right, then you have to actually cite with regard to multiple laws that talks about those, right? Like Vienna Convention, right? Individualism is also grounded with regard to grave breach of four Geneva Conventions, right? So if you remember 2, 3 articles, you write it down or you can write it generally. Okay. Similarly, UN Charter also talks about individual. Okay. Similarly, with regard to Convention on Human Rights or International Convention on Elimination of all forms of racial discrimination. So racial discrimination against whom? Actually, it is individual, right? So what you can do that if you remember, it is better. You can write multiple articles of these convention and point out that indicate that individual has to be protected, right? Like doctrine of proportionality. If we say with regard to doctrine where a person has to protect a state has to protect its own existence, right? Then a person can use atomic bomb also. Sorry, a state can use atomic bomb also, right? So in that case, when we say that a state have been extinguished or the state will be destroyed, what actually we mean by that? We mean that the individual residing in that state will get destroyed, not the property, not the building. Okay, right? So in fact, you can make you can cite multiple article and attach that how actually it is the individual which we are talking about, right? Here one thing is not written, right, but that can be also added. That is with regard to how European, humanitarian law treaty have given right to Europeans to approach, against a particular state in the European Human Right Council, right? Can individual can sue a state, right? See, Europe is very advanced, right? They have reached a level which we cannot even think of, right? Like, for an example, this concept of European Union. What we study in normal law, that sovereignty is very precious to a country. We study it. That is very simple. That we always study sovereignty is very precious. But still, they have, chosen to sort of pool their sovereignty, right? All the European countries and make a semi-sovereign sort of, European Parliament, European Court. Okay, so they are, at a very different level politically, right? We cannot even think of that, right? We cannot even think of South Indian, nation. Can you think that they can, come together like Europe and have sort of a, even though they have a very similar culture, we won't, right? We won't. So that is something very different. Europe are at a very different level. We will obviously, reach that level obviously after God knows 100 years or so. Okay, done. Now I will take questions. If you have any questions, please go ahead and ask me one by one. One is saying that is conclusion mandatory for every question as answer. No, not at all, Geeta, not at all. Origin of good is different. The concepts are, yes, it is a different concept, but in the like product, origin of good becomes a relevant question. Okay, origin, purpose. There are multiple methods also. Okay, any other question that you might have, go ahead and ask me. I will definitely answer it. Yes, I have no questions actually, right? So there is one more question here, but that is a question of, it is not a question of international law, but I could have checked it, right? But I will check it. I mean, you write one question, any one of it, okay? So this is question number 5 of paper 2. Sorry, paper 1, part 2, part B, okay? This is 2020 paper. You write, you take any of the question that I just explained, okay? And this video will be there on the website itself. If you want to watch it again, you can watch it again and you give me a model answer, okay? Now, do not actually write what is written here itself, okay? Don't do that, right? You read it once and try to write by your own, because in exam, there won't be any model answer, okay? Try to write by your own. Yes? How can I have access to previous video judgment? This is already there on the website, okay, Sachin? You can go and see that on the website. No need to, actually You can go and see that on the website. Okay. You can raise your hand also. I can you can raise your hand. There will be a button of raising hand, right? You simply click that button. You can raise your hand, and I can. Is contemporary compulsory to mention case law? Yes. I mean, if possible, you should, right? You should. But if the question is very generic, like suggesting reform the UN, there's no case for that, right? There's no case for that. Geeta is asking that I am getting high marks in law optional. Should I mention for getting high section B? Yes, you should. You should, Geeta. You should. Where should you send your written answers? You can send your written answer on de facto law website, defactolaw.in@gmail.com. Okay, here you send it. I will also. I also have this login and password of this, right? So I will see that. Okay. Please continue this series. It is very helpful for law optional. Yes, yes, I will try to continue. I will try to continue. Hello, sir. I am from Manali, Delhi, preparing for. Can I ask something in general with respect to answer writing? Yes, Tanisa, go ahead. You can ask, obviously. Do we have to write case law in every answer? If yes, then how many? It is not fixed how many case law you have to write. Now, don't message to everyone. Okay, message to everyone. Do not only message me directly, right? Message to everyone. Okay, publicly. If you message, then everyone will understand what is the question. You need not to unmute yourself. You raise your hand and I will unmute you. Okay. You raise your hand. What is the name? Tanisha. And I will unmute you. Okay. You raise your hand. There's an option of raising hand. You can raise your hand and I will unmute you. Okay. Tanisha. Otherwise, I will have to search your name. Yes, Tanisha. Go ahead. If anyone have any question, they can raise their hand. Yes, Tanisha. Go ahead.
Hello, yes, sir. I just wanted to ask, like, I was looking at the past year papers, and so I was first starting with constitutional law. So I had to ask, like, if you're preparing case laws or studies, so like some questions were very specific, like fact situation, and the facts were based on one particular case. Which was like that Indra Jaising case and other cases. So like how do we prepare for such cases? Like how do we prepare for case laws, because sometimes it can be very general.
See, Manisha, Tanisha, right? Tanisha, if you will go to the YouTube, right? So I have there done a very interesting thing that I have taken one topic, right? And in that topic, I have explained that what type of question comes and how to handle that. Okay. Topic by this, this video is there. Okay. So that is a very remarkable thing. If you want to really serious, right? You should go through that whole series of constitutional law, right? So there are around 12 lecture on the constitutional law of 30-40 minutes each, where I've explained each topic that what to study in that. Okay, so if you have time, you go through that. You will have a very clear picture on that.
Yes, sir. And just another question is that what about parts which are not like explicitly mentioned in the syllabus, like the state legislatures or the official language or even trade and commerce? It is not
question on that. Like with regard to taxation, right? There has never been a question on taxation normally, right?
Yes, sir. Yeah, exactly.
Yeah, so you don't need to study that at all. Whatever is not mentioned, but study preamble, right? Preamble is not mentioned, but preamble comes, right? Similarly, citizenship is not there. You must not have seen any question with regard to citizenship. Okay, so if you are a law student, you can sort of overall study about the citizenship, right? But do not go into much detail about it. Okay, so whatever is not mentioned in syllabus, do not bother. Okay, do not bother at all. Okay.
Okay, sir.
Thank you. Yes, anyone else have any other question? No? Arya Bhandarkar. Yes, Mr. Arya, go ahead.
Sir, I had a question which was more of a general nature. Sir, I saw these one or two videos from toppers who were saying that although they were doing well in law college, like in law college, they were doing well and they were toppers over there, but they were not able to understand the demand of the paper in the law optional in UPSC.
That is why this is something which is going to help you immensely. Yes, what is? Go ahead.
So what is the difference exactly? Because for me, when I think of what will come in constitutional, for example, if they have asked about creamy layer, then there are two particular articles, there are 3 or 4 landmark cases that have to be told, and there is not much difference that you can do over here. Then sir,
you can. No. This assumption is very bad. See, understand this thing. This is a very good question, right? Those who are new to law optional preparation must have this question. See, what happened that two things happens actually. First, in university, you have the mindset of solving 5 to 6 questions in 3 hours. Okay, here you have to solve almost 18 to 20 questions in 3 hours. Right? So the first thing that you must remember that when you write a particular case, right? So instead of writing its fact, etc., you should focus on the crux of the case. Like for an example, suppose Shreya Singhal you have to cite, right? So either you can cite that there is a law, IT Act, Section 66A provides for it, and ultimately court held this. No. So instead of that, you can write in very one line actually. It was a case related to the validation of a 66A of the IT Act, and court held it invalid on ground that it violates breach fundamental right to privacy, which the court read into Article 21, right? So it means in one line you quoted that case, right? So the question that you are asking with regard to suppose reservation, you have to cite Article 15 or its subsections, right? So instead of citing it, as it is, you should try to reframe it and make it more, sort of a very abstract, right? Very, very condensed form, right? So if you go on writing the whole, the case with regard to suppose OBC reservation, if there's a case, right? So if you go on citing the whole case of Mandal Commission, that will be counterproductive. Okay, so you have to practice a method where you have to, sort of, that is basically one of the good lawyering also, right? In court also, you have only 1 to 2 minutes to explain to the judges with regard to what is your proposition, right? So you cannot go on, talking about everything. You have to, come up with, and that is where the writing practice comes into picture, right? You have to condense it. Understand? So that is something. And second point that is important, that is with regard to the answer that you write, right? You write legalistic answer, that is obviously important, right? But you need not to be, go into too nitty-gritty. Sometimes you will see, 10-20% of questions are very generic in nature, in which no case law, nothing is to be written. Like suggest reform in ICC. What case law you will write in that? Suggest reform in UN. What case law you will write in that? Okay. So there are certain questions which university, you will never get those type of questions in university, right? So here that has to be adjusted. Okay. Okay. Now one more, I think, who have raised her hand? Mr. DA. Yes. Please go ahead, DA.
Hello.
Yes, go ahead.
Sir, my question pertains to the international treaty specifically. Where, sir, actually, I am having a hard time, remembering and recollecting as to what articles should I, repeatedly study and make notes about. Because, sir, different year questions have different amount of different types of question relating to treaties. So, sir, could you guide me through what important articles you should like?
Same thing you go through on international treaty. As for international treaty, also I have made a specific video that what are the subtopic that you need to study. Go through that video, 20-30 minutes video that is, okay? You will understand.
Okay, sir.
Okay. One more last question I will take. One who is raising the hand, Konthabe, he is gone now. He or she who have raised the hand. Okay, then I think that will be enough. Vatsala, I think Anu Bolu Vatsala, I think I have answered your question, right? Okay. So let us wind it up for today. Any other question? Now remember, the class will be daily on Thursday and Monday, right? So today is Monday, so on Thursday I will take the class. Okay. And please, if you want, you can submit one answer. Okay. Now this will be uploaded on YouTube, but not so sure when it is going to be uploaded on YouTube. Okay. But it will be. Okay. Thank you, everyone. Then let us wind it up. Okay. Thank you.